Kelvin Davis.
Thank you, Mr. Chair. And I'd like to speak to Clause 4 of Part 1 of the Public Safety Public Protection Orders Bill, which Clause 4 talks about the objective of the Act, and the objective of this Act is to protect members of the public from the almost certain harm that would be inflicted by the commission of serious sexual or violent offences by people who are currently coming to the end of their term. Just going to the definition of serious sexual or violent offending, it means the commission of one or more serious sexual or violent offences. So we are talking about a small subsection of people who are currently in prison that upon their release within 6 months are expected, despite their punishment in prison, despite their attempts at rehabilitation, they're more than likely going to recidivise and cause harm to members of the public. And I think any New Zealander says, yes, we need to have something that is going to protect New Zealanders from the threat of harm from these people. But as Jacinda Ardern has just said, the public protection orders are not to be considered an extended form of punishment. We can't, we can't punish people twice for the same crime. It's called double jeopardy. But I just have to say that there are concerns around the Bill of Rights, as Jacinda has touched on. So the Attorney General expressed the opinion that the bill is not inconsistent with the New Zealand Bill of Rights Act 1990. The Attorney stated that the critical issue is whether the provision, is whether the provision for detention and other measures under the bill in substance amounts to further punishment of sentenced offenders, contrary to the long-standing rights against arbitrary detention and double jeopardy affirmed in sections 22 and 26 of the Bill of Rights Act, or to civil committal as provided for in other New Zealand legislation and widely held to be compatible with these rights. The risk of breach of sections 22 and 26 was raised at the time that the bill was proposed. The Attorney General concluded that unless the bill incorporated the key safeguards necessary for a civil committal regime, it would not be Bill of Rights compliant. The bill as introduced includes such safeguards at each of the stages of the making, administration and review or cancellation of orders. The bill also contains broad interpretive principles to ensure its operation as a committal and not a punitive regime. In other words, there are safeguards there, apparently, Mr. Chair, so that people aren't going to receive, or they're not going to come under the double jeopardy Act. So also in Clause 4, Part 2, it's not an objective of this Act to punish persons against whom orders are made under this Act, even though if they are subject to a public protection order, they will still be kept in prison, but in not in the secure wing. In fact, if we go to the principles in Clause 5, it's Clause 5D says persons who are detained in a residence under a public protection order should have as much autonomy and quality of life as possible while ensuring the orderly functioning and safety within the residence. So that they are to be kept within a residence, within prison confines, and they're to be given as much autonomy to go about their lives as possible, but without being out there and posing a threat to, of serious sexual or violent offending against New Zealanders. Other principles in the bill, Mr. Chair, 5A says orders under this Act are not imposed to punish persons, and the previous commission of an offence is only one of several factors that are relevant to assessing whether there's a very high risk of imminent serious sexual or violent offending by a person. The A public protection order should only be imposed, Mr. Chair, if the magnitude of the risk posed by the respondent justifies the imposition of the order. So there has to be some consideration to the magnitude of the risk that the offender may pose to the community. Also, one of the principles is that a public protection order should not be imposed on a person who is eligible to be detained under the Mental Health Act. So in other words, if they have a mental disability, they cannot be detained under this bill. They won't be subject to a public safety, public protection order. And as I've said, Clause 5D is about giving these people as much autonomy, even though they'll still be restricted within prison confines. There are thresholds, Mr. Chair, a threshold for imposition of these public protection orders. The person must be aged 18 years or older, so anybody obviously under 18 years of age would not have a public protection order put upon them. And also the person is detained in a prison under a determinate sentence for a serious sexual or violent offence. So for the benefit of people listening, a determinate sentence has the same meaning. Well, it basically means that they're in there for a set length of time. Another threshold is the person must be released from detention not later than 6 months after the date on which the Chief Executive applies for a public protection order against the person. The Chief Executive, meaning the Chief Executive of the Department with the authority of the Prime Minister for the time being responsible for the administration of this Act, and that's generally the Head of Corrections, Mr. Chair. We look forward to debating this bill thoroughly and going through each of the parts, Mr. Chair, and with that, kia ora.